morning. My name is Ryan Mick, and it's my privilege to be the practice group leader for Dorsey's Labor and Employment Group. And so I also have the privilege in turn of getting to welcome you all, both in person and online, to our 13th annual Dorsey L&E Symposium. It is always true, but it's worth repeating. Looking back over the years, we do our jobs. You do your jobs in dynamic times. This isn't the 80s, this isn't the 90s, this isn't the early 2000s. You know, for those of us who have been around a little bit longer than others, you know, the last few years have really been as dynamic as I've seen. You know, first it was a regulatory environment that we had never seen in the late teens. Then we had the pandemic, of course, and all the uncertainty around that. Then we had the end of the pandemic, and particularly in the employment space, all the uncertainty with that. What would it look like to come back to work? What would remote work involve? You know, how would things change from a regulatory, from a cultural, from a litigation, from a just day-to-day HR environment? You know, that was something that all of us together had never dealt with. Then we've had political uncertainty. The change of administrations kind of in the middle of all that. And this year, for different reasons, is no exception. We have some really remarkable legislative changes, particularly for those of you who practice here in Minnesota. But not just limited to Minnesota. We're seeing legislative activity at a level we haven't seen before, coast to coast. We also have some entirely new dynamics. We're going to have a session, I'll mention here a little bit later, about workplace privacy. In one sense, it's been around forever. We've had drug testing and background checks. But it's a new world on that front in particular. Things that we're going to talk about that are important, restrictive covenants, for example, our first session, we at least know what we're talking about. You know, whether they're enforceable or not, we know what restrictive covenants are. But when it comes to AI and other dynamics of workplace privacy, we are looking at horizons that, you know, frankly, we have never really had to grapple with as HR and employment lawyers before. And so we want to spend some time with that. But anyway, you know, you don't want to listen to me pontificate. Let me just say thank you. You have entrusted us through all of those years, through all of that change, as your advisors, as your representatives, as your in-court counsel, and we're grateful for that. And we're grateful for the steadfastness that you've shown to us. And that includes events like this. It's my great pleasure to be able to announce to you that for the first time we've broken 1,000 registrants. I think we're about 1,100. And I got to tell you, for those of you who are online and can't see the audience, it's kind of like 2017. We have a full room. I think we even have a little bit of overflow, which brings, again, some of us who have been around a little bit longer back to the pre-pandemic times. And just great to have a room that's full, to have conversations going on during breaks. So I'm really excited to have another session with you all and to see so many of you in person. I do have to do some housekeeping. Please don't forget to sign in for each session. For those of you who are here, the green sheets are on the table. Please make sure you sign into those. For those of you who are attending by webinar, the materials and attendance form are available for download from the login and the materials email that was sent from events@dorsey.com before our session today. Webinar attendees also don't forget to return your completed attendance forms to attendance@dorsey.com. Dorsey will be applying for CLE and HR credit in the jurisdictions that we listed, so your signups are particularly important if you want that credit, and we know you do. We know that's why you're here. This year, we're not going to have dedicated time for questions. We have so much material that we wouldn't be able to do it justice. And frankly, if the last few months of interacting with so many of you by phone and over Zoom is indicative of anything, I'm not certain we'd actually have time to talk through our presentation materials if we answered all those questions, because there are a lot of them. So we apologize for that. We won't have dedicated time for questions, but please feel free to reach out to your Dorsey contacts. I think in all of our slide decks that you have in hard copy or online, we've given you phone numbers and email addresses for our folks. So if you have a question and you don't have a contact, just give a call or send an email to one of the panelists. And if you lose your materials, we're all online, so feel free to reach out to us in that capacity. Those of you who are attending by webinar, we also have links to the materials in the chat, so make sure you check that out if you haven't seen it already. Very briefly, let's talk through our agenda. We, again, have what I hope will be some very practical sessions for you as we recognize you are grappling with some substantial changes. We always try to do that, and this year is no exception. We want our sessions to be not just telling you what the law is. You can read about that, but we hope that these sessions are very practical. The first one, I hope, will be no exception. The first one, we'll talk about restrictive covenants, one of the more dynamic areas of change over the last year and probably for the next few years to come is what's happening with restrictive covenants. We've had the current administration rumbling about restricting those from the very beginning. We had a very substantial change, as I mentioned, in Minnesota this year. And frankly, we've had some unexpected entrants into the race to cut out non-competes, including the National Labor Relations Board, which we'll tell you about here in a moment. So a lot of dynamic movement in the area of restrictive covenants. Next, we'll have a session on leaves and accommodations, a perennial favorite. I think I can speak for all of us that if I had to rank, the top one or two categories of questions that we get on a day-to-day basis, leaves and accommodations, if it's not number one, it's number two. So something that we know that you like to hear from us on a year-to-year basis. And another area where we actually have some legislative change for those of you who are practicing here in Minnesota that we'll tell you about. Another perennial favorite, employment litigation trends. You all seem to like to know what the plaintiff's bar is doing and what's coming down the pike in the courthouse. So we'll spend a session telling you what the litigation landscape has looked like and where it might be going over the next year. And then our final session, one that I'm particularly excited about, gets into the workplace privacy issues that I mentioned. Guarantee you're going to learn something that you had no idea you needed to even be paying attention to in that last session. Every time I have a conversation with one of our panelists or somebody else, and there's lots of dynamics to the privacy issue outside of the workplace where there are intersections. Again, every time I have a conversation, I learn something new, and not just how to not to solve it necessarily, but just something that I didn't even know was out there as a risk. And so we want to talk to you about those sorts of things. We will take short breaks. Again, we've tried to have a pretty aggressive schedule to get you out of here and back to your regular work day. But for those of you in the room, we recognize that 5 minutes might be a little bit tight for the restrooms. So those of you online, if we extend the breaks just a little bit, bear with us. We want to make sure that everybody has a chance to participate. So with that, we will go ahead and get started. Again, our first session is on restrictive covenants, and I'm going to make the short walk over to the table here in a moment, but let me first introduce my colleagues. First will be to my immediate left, Briana Taqatqa. Bree is one of our senior associates. She litigates these sorts of cases in a variety of respects and a variety of industries. And she's also been one of the leading associates to keep us all up to date on the various changes that have come down in this area of law. Next to her is my partner, Jack Sullivan. Jack also litigates and advises in this area. He is also one of our deep traditional labor experts. And so when we talk about the unexpected entry in the race to limit non-competes from the National Labor Relations Board, Jack will talk us through that. And it's not just non-competes. The NLRB has been very active in a number of restrictive covenant areas. So lots to talk about on that front as well. But we're going to start with a discussion of state and federal trends. We'll talk about trade secrets. Not something that you might have expected to hear from us when we're talking about new developments, but something that I think is important to talk about because as some other restrictive covenant options are more restricted, we need you to look back at some of the more basic things like trade secrets and make sure that those are firmly protected as other restrictive covenant options wane. We'll talk about the NLRB, we'll talk about the Minnesota statute. I know there's a lot of interest in that and some open questions that we're going to have to grapple with over the next year or so. And then we'll try to spend as much time as possible talking about some very practical takeaways. But we're going to begin with our trends, and I'll turn it over to Bree.
So we wanted to start off with an overview of some trends that we're seeing at the state and federal level. For those of you that joined a couple of months ago, we did a presentation in a full hour just on this topic because there's so much to talk about and there's new things even since then to talk about. So plenty of material. In general, we are seeing a trend toward more restrictions on non-competes. State legislatures are taking action. We're seeing sort of this shift away from the traditional common law framework, which was that non-competes and restrictive covenants were generally enforceable so long as they were designed to protect a legitimate business interests and reasonably tailored in terms of scope and duration, things like that. We're kind of seeing a shift away from that common law framework and more toward a statutory framework where states are putting in place strict requirements for enforcement of non-competes. And a couple of the examples, the primary things we're seeing are on the slide. The biggest one I would say is salary threshold. States are putting in place requirements that non-competes are not enforceable for employees who earn below a certain salary threshold. And those vary depending on the state. Just to give you a couple of examples, some of the states are, around 100,000, around 75,000. We'll look at some specifics on the next slide. We're also seeing things like notice requirements. And the state I'm going to use as an example for a lot of these is Oregon, because they have multiple of these requirements in place. Things like the employer, if the non-compete is a condition of employment, the employer has to give the employee at least 2 weeks advance notice before the first day of employment. Term limits. Oregon also had some recent activity. They reduced the maximum term for non-competes from 18 months down to 12 months. So now in Oregon, it can only be a 12-month post-employment restriction. And then things like garden leave. These are kind of unique policies, but essentially the Oregon legislature has said, okay, if you want to have a non-compete for an employee who earns below the minimum threshold, you can do that, but you're going to have to pay them at least the minimum salary threshold for the period that you want to enforce that restriction. So those are some of the trends we're seeing. The newest one that I want to point out at the bottom of this slide is a sneaky trend toward also prohibiting non-solicit agreements. And we're starting to see this pop up. It's been there in California, and now we're seeing it in other states, including Colorado and Illinois. So the Colorado restriction is a salary threshold restriction, like its non-compete restriction. So in Colorado, you cannot have a non-solicit agreement for employees who earn less than $67,500 per year. And it can't be broader than necessary to protect trade secrets, very specific and foreshadowing to one of our next topics. In Illinois, the salary threshold for customer and employee non-solicits is $45,000. So for employees earning less than that, those restrictions are also prohibited. So that's sort of one of the newer trends we're seeing as well. This is kind of a summary slide of the categories of restrictions that we see. So we have outright bans. Those states are listed up on the slide. Of course, Minnesota joined the ranks in July this year. We've got, we're going to spend some time talking about that a little later on. And then some of the other states we're familiar with have had bans for a while: California and North Dakota. Washington, D.C. is pretty new. Of course, it's not a state, but I included it anyway. But theirs is relatively new. And then, I mentioned this common trend of salary thresholds. That's something that we're seeing across multiple states. I've got them listed up here. The example I'll give for this one is Illinois. Their salary threshold is $75,000. That number will increase every couple years to keep up with inflation. Of course, who knows how you do that, but and then interestingly, kind of a different twist on that, Nevada has a restriction for hourly workers. So regardless of how much they earn per hour, non-competes are void for hourly workers in Nevada. So that's a different twist on that. There's a couple other states that have restrictions. Just for those of you who are multi-state employers, if you have employees in Georgia, Louisiana, Massachusetts, or Utah, they have other requirements in place for enforcements of non-compete agreements. And then there are certain specific limitations in some states for certain professions, like healthcare workers in those states include Indiana, Iowa, and Kentucky. So if you operate in those states, you should be aware of those restrictions. All right, and then just briefly at the federal level, we're seeing some action as well. The action is sort of stalled at the moment. The FTC proposed a rule that would prohibit non-competes nationwide for every worker, independent contractors, employees, paid, unpaid alike. That rule was introduced in January. There was a lot of buzz around it. We've talked about it at a couple of these presentations that we've done in 2023. The comment period ended in April, and the FTC recently announced there's going to be a delay on the vote, probably until April of 2024 at least. And part of that is because, as you can see on the slide, they got 27,000 comments, which is a lot of comments to read. So it's going to take them a while. So they're working their way through that. So we're still kind of in a wait and see. I think, you know, this rule got a lot of attention because it's obviously very broad, it's nationwide, and it would apply retroactively. So it would actually require employers to rescind agreements that they have in place, which is different than what we're seeing in almost all of the state bills that have passed in recent years, including Minnesota. So that's why that's one of the reasons this got a lot of attention. And I'm sure at least a few thousand of those comments touch on that issue. So wait and see for now. The high level takeaway on this is that whatever happens, there will be litigation, especially around whether or not the FTC even has the ability to make such a rule. So we'll keep eyes on that over the next year or so.
All right, so Bri, I don't think we're recording, so I'm going to put you on the record.
I think we are recording.
Are we? Okay.
That's okay.
Well, I'm going to put you on the record anyway. Totally binding prognostication here. So we've got, you know, California, that's always been California. We've got Minnesota that really did something that's pretty stark. We've got all these states, we've got the feds. Having looked at what's happened, what's coming next?
I think more of what we're seeing. I think we can expect more states to take legislative action. I don't know if we will see a lot more outright bans like what we've seen in California and now Minnesota. But I do think kind of the hybrid middle of the road approach, things like salary threshold requirements, term limits, you know, legislatures sort of setting rules for what makes for a reasonable restriction in terms of how long it can last and things like that. I think that is definitely something to be expected. And so we'll keep an eye on that. We'll continue to update you as those changes happen. At the federal level, it's hard to say. I mean, I don't know what's going to happen with FTC. I'm not going to commit to anything on that on the record, other than what I said a minute ago, which is that litigation is imminent, I would say.
All right. We'll talk a little bit about trade secrets. Now, as I said, in a sense, there's nothing new here. But before you take too much of a breath of relief, I think it's important to look at this, as I said, because as other options start to be restricted, you know, non-competes are limited, maybe even non-solicits, depending on what we see in some states. Who knows if we're going to have a federal ban? One of the things that is almost certain to stand is the protection for trade secrets. And so as other options limit, we want to make sure that we kind of go back, step back, review and refresh to make sure that you are on solid ground with respect to your ability to protect your trade secrets. Again, those are probably going to survive the legislative onslaught. I think it's important from a litigation standpoint, because if you can build in a trade secret case to a case to enforce other non-competition, non-solicitation provisions, that really enhances the case. Judges, you know, quite apart from other things that are happening, they still seem to be quite willing to protect trade secrets. So if you can integrate a legitimate trade secret claim into a broader piece of litigation to enforce something, you're going to strengthen that case pretty substantially by that. That said, although trade secrets are nothing new and the protection of trade secrets are nothing new, as we've thought about this and kind of reevaluated what clients are doing in the space to protect their legitimate business interests, I have a sense that focus on trade secrets and care in the enforcement of those trade secrets and the protection of those trade secrets has waned. Attention has just kind of gone elsewhere. And I see a lot of clients who have just lost track of, frankly, what a trade secret is, because a trade secret is not any and all confidential information. And they've also lost sight, to some extent or another, of what it takes to protect a trade secret. You can't just say, hey, I've got a trade secret and Bob stole it on the way out, so I'm going to sue him. If you haven't taken steps to protect it, you might be out of luck if you want to enforce that trade secret protection. So we wanted to spend a little bit of time as a refresh on what a trade secret is and what you have to do to protect it. So from a definitional standpoint, we've given you on the screen here the definition of a trade secret from the Federal Defend Trade Secrets Act. This is the particular federal language, but roughly speaking, there's some differences. This is more or less analogous to what you see in most Uniform Trade Secret Act state statutes. I'm not going to go through the entire list of categories because, in a sense, if you start from that first paragraph, the definition of a trade secret can be broad. It can fall into any category of confidential business information. But there's a big, bolded, underlined if. There are some things that you have to do to protect your trade secrets. Number one, you have to have taken reasonable measures to keep that information secret. That's the key to the protection. The second paragraph is my earlier point, that is, not everything is a trade secret. So as much as we want to emphasize how important it is for you to make sure you're protecting your trade secrets adequately, don't think that this is the silver bullet that you can protect everything, because not everything is a trade secret that's going to allow you to rely on the statutory protections. It might be confidential, and if you've got a good confidentiality or non-disclosure agreement, you'll still have some protection. But when we're talking about trade secrets, not everything is a trade secret, primarily because it may be reasonably ascertainable through proper means outside of your company. So again, where do employers fall short? We see a couple of areas. Number one, proving that their trade secrets are not, I'm taking these out of order because I'm going to spend a little bit more time on the reasonable measures, proving that their trade secret is not readily ascertainable. Key example, common to most companies, is the customer list. Everybody wants to treat their customer list, whatever that form might be, online, paper, no newspaper anymore, Excel spreadsheet, whatever. But is the customer list really a trade secret? Kind of the perennial counterexample is the company where you can figure out who the customers are by going to the Yellow Pages. Nobody uses Yellow Pages anymore, but you get the point. If you can recreate that customer list just by going to Google or by going online, you might have a hard time arguing that that customer list is a trade secret. It needs a little bit more. Now, that said, there are cases out there that say that you can have a trade secret in and of something that is a combination of publicly available and non-public information if you integrate it in a unique way that provides value to your company. But just be aware that not everything that you think is confidential would rise to the level of a trade secret. There has to be some level of secrecy as a bare minimum. And that secrecy can fall in a variety of ways. Again, it could be publicly available in the Yellow Pages. Maybe it's something that you share with vendors. Maybe it's something that you've disclosed to customers. Kind of hard to argue that there's complete secrecy if you've disclosed this. Maybe you've advertised it in some respect. So just be aware that as you're thinking about, do we want to protect a trade secret, make sure that you're talking about something that involves your efforts to maintain secrecy. And there's probably a business judgment to that. You may need to disclose things, but there's a cost to that in the sense of losing some control over something that might otherwise be a trade secret. Then the first thing on this slide, and the one that I do want to emphasize, is failing to take reasonable measures to keep that information secret. Mental exercise. I'm not going to put anybody on the spot here, but imagine you are sitting in the deposition in your plaintiff trade secret case, and the former employees counsel looks at you and says, all right, I want you to catalog all the steps that you take to maintain the confidentiality of your trade secret information. Go. I think a lot of us would struggle with that. And I want it to be otherwise. I want you to be in a position where if you're called upon, you can articulate not just the one or two things, but the catalog of efforts that you take to maintain the secrecy of your trade secrets. To be clear, I said absolute secrecy before. That was a slip of the tongue. The cases are pretty clear that it doesn't have to be perfect secrecy. That you don't have to be Fort Knox, but you do have to demonstrate reasonable efforts to maintain secrecy. So what do you do about that? We'll come back to this when we get to the practical segment at the end, but I wanted to give you some categories. Create a culture around the importance of confidentiality. Make sure your employees know that confidentiality is important. Kind of another mental hypothetical. If you asked your workforce, Is confidentiality important to this company? Would they immediately say, oh yeah, you bet? Or would they think about it? Or would they say, gosh, I don't know. Nobody really talked about it. I probably signed something when I started, but nobody's really talked to me about it. Implement regular training. Hard to say that something is important, like secrecy, if you're not training your employees on it. Restrict employee access on a need-to-know basis. Make sure you implement security measures. And going back to my earlier kind of tongue-in-cheek comments about being longer in the tooth, it's not just lock and key, but that's still important. We're now in the realm of electronic protections as well. We'll talk about that a little bit more. Monitor employee activity for signs of misappropriation. Again, you're not running prisons, but do keep your eye on what employees are doing. You've got some options that we'll talk about a little bit later. Develop termination procedures. How are you making sure that somebody's not walking out the door with your stuff? And in particular, enforcing return of property requirements upon separation. Last but not least, develop a plan for inadvertent disclosure. Mistakes happen, something slips out, but don't be caught flat-footed when it does. And I'll share some ideas a little bit later on about that when we get to the more in-depth discussion about practicality. So with that, let's talk about the NLRB, Jack.
I'd be glad to. It may seem to be a bit of a digression into a different topic field to talk about the National Labor Relations Board in a conversation that's primarily about trade secrets and confidential information, but there is a connection, trust me. Really, we thought we would we wanted to include this as a topic area in this conversation because you really can't talk about the current environment facing employers without a conversation about the way the National Labor Relations Board is approaching its traditional areas of enforcement. So just by way of background, so the National Labor Relations Board is the federal agency that investigates alleged violations of and enforces the National Labor Relations Act. It has jurisdiction in all workplaces, regardless of whether there is a union afoot, whether there's a union that exists, or whether there's a unionization campaign underway. Right now, charges of unfair labor practices are at an all-time high. If they're not still at an all-time high, they're close to that. And that is coupled with an approach and a philosophy from the Biden administration's National Labor Relations Board that is, I think, accurately called an all-time high in terms of its pro-union stance. And just by way of an example of what that means is that there are new rules that are being put in place about what employers can say, what they can and can't do if there were a union campaign that is really changing the way this area has been practiced for the last 50 years. Just as a couple examples of that, it was a long time approach that when a union petition is filed, an employer would have a mandatory meeting of all employees to start presenting its case about why the employees should vote no for the union if that was the position the employer was taking. Mandatory meetings currently prohibited. They're viewed to be inherently coercive, and just even setting one with the threat of discipline creates a coercive environment from the labor board's point of view. The labor board is also seeking to undo sort of the election process itself and go back to a day that didn't exist very long in history, but in the late 60s, when it was possible for a union to just simply present a bunch of signed authorization cards and say, look, we've got a majority of people who want the union, start bargaining with us. So since the early 70s, employers have been able to say, no, we just would like to see an election. We want there to be a full and fair election, and we'll abide by the consequences of that. But for the time being, we're not just going to basically take your word for it. So in light of that, or with that sort of as the backdrop, earlier this year, the labor board issued a decision called McLaren, which for the first time, I believe, took a strong stance about what sort of promises can be sought by an employer in a severance agreement. So here we start to see the connection to the trade secrets and the confidential information. So what the McLaren decision said is that if an employer insists on a confidentiality provision in a severance agreement, that insistence violates the National Labor Relations Act. Their theory in this is that So one of the core rights that all employees have under the National Labor Relations Act is the right to engage in what they call concerted protected activity. Perhaps protected concerted activity. I never really remember which one comes first, but it's protected, it's concerted, and the prohibition in this instance is that part of that collective action that employees should be allowed to take is to discuss with each other the terms of their employment. You know, hey, I just got fired and they're offering me a separation agreement. They're offering me 2 weeks of pay. What did they offer you, Josh? Was it 2 weeks or was it 6 months? So that sort of conversation is something that the current administration is saying is protected under the National Labor Relations Act. So by offering and insisting on a severance agreement that requires that sort of confidentiality is according to the board, a violation of the Section 7 rights, the National Labor Relations Act rights of the employee who was offered the agreement. They've taken the same approach to what they call, non-disparagement clauses. So don't talk ill about us, and we are good. You will not violate the terms of your separation. You can continue to keep the money that we're paying you if you just like speak nicely about your former employer. The theory here is that concerted protected activity includes the ability to talk ill about your employer, to say, I had problems with where I worked. I didn't like these things, these policies that the employer had. And so therefore I should be able to say whatever I want about them, even if it's, quote, disparaging, which the board sort of identified as sort of a vague term. What is disparaging? It's not defamation, for example, it's not false, it's just sort of generally negative. So that's where the board has taken a step sort of farther into the relationship between an employee and an employer than they have in the past. Related to this, and sort of as a breaking news update, if you want to call it that, too recent to make it onto the slide, is you may have seen that there was a decision yesterday where the labor board has applied the same mindset about confidentiality and about workplace rules to employee handbooks. So if you've been in HR for a while, if you've practiced in employment or labor law for a while, you know that there's sort of the swinging pendulum of rules that can apply to certain aspects of the workplace. One of them is employee handbooks and policies. So as of yesterday, the board has gone back to the sort of early 2000 era rule that if an employer adopts a policy that has what they call a chilling effect on an employee's rights under the National Labor Relations Act, that policy is presumed to be unlawful. So this would be something like professional conduct. If there's a rule that says you need to abide by standards of professionalism in the workplace. The theory is, unionization efforts can be ugly and can be difficult and disruptive. And so you can't have sort of a conduct rule that might make an employee who is thinking about engaging in some sort of union activity. Maybe they want to wear vote yes buttons or something like that. Maybe they want to, who knows what it might be, but it's something that the employer might say that's disruptive and disrespectful. Well, a rule like that is sort of now presumed to be unlawful. Confidentiality rules, depending on how they're worded, can also fall into this category. So there's sort of a core part of the National Labor Relations Act is that employees need to be free to talk about how much they make, talk about their benefits and things like that. So when you're making the list of trade secrets and confidential information, either in a policy or in an agreement, and you say salaries are confidential information, what people make are confidential, that is not going to be, it may violate certain state statutes, so, but it also will, under the current approach of the board, violate the National Labor Relations Act. So it's important to kind of keep in mind one thing here, and that is kind of taking a step back. The National Labor Relations Board, it does have jurisdiction over all workplaces, but they're not out there investigating, looking for trouble. They respond to complaints that are filed with them. So they have jurisdiction when there is a charge that is applied. And their jurisdiction applies to basically non-supervisory, non-management employees. So there's a statutory definition of who is and who isn't an employee. That's, trust me, an hour-long conversation that would put you all to sleep. But the important thing to know is this doesn't mean you can't have confidential provisions and executive agreements. It doesn't necessarily mean that the labor board is going to come knocking on your door if at the kind of the highest level of the enterprise, there are certain agreements and certain commitments in place. But to the extent that rules are attempted to be applied to, the rank and file employees in an organization, the labor board will be interested in looking into that if there is a complaint. But keep in mind, complaints are at an all-time high. Part of the reason they're at an all-time high is because of a high amount of public attention and public awareness on kind of unionization and collective efforts. I mean, you only have to pick up your phone and see the latest alert from a Starbucks organizing effort or Amazon or something like that to know that this is sort of in the popular mindset and popular awareness to a degree that it may not have been in the past. In a really, I think I've said unprecedented number of times in the 5 minutes that I've talked, but the board chief administrator, a person who holds the title of general counsel to the National Labor Relations Board, issued a memorandum earlier this year to all the regional offices that she oversees to say that, we also have a problem with non-compete agreements. So this is after the FTC had done this. There's the state law attention that is coming to bear. And the board is taking this position that I'm not aware it's ever taken before, that that non-compete agreements are discourage employees from exercising their Section 7 rights, their rights to collectively act together and engage in concerted protected activity. And the way that the board gets there is a little, I think the legal word is sketchy, but they get there. And the way they do it is sort of what we have here on the slide. So that, employees should have the right to say, you know what, if you don't improve my pay, if you don't improve my benefits, I'm going to walk. And the theory is, well, if you're under a non-compete, the employer can say, yeah, whatever, you're not going to walk because I have a non-compete that says if you walk, you're not working in this industry. And so that then chills or discourages the employee from making that I'm going to quit type of threat. And then there's this other sort of theoretical idea that employees won't actually resign if they do threat because they can't go and get a new job because they're subject to a non-compete, and that in and of itself is a violation of the National Labor Relations Act. It also, the limitation on people being able to find a different job in their industry, according to the board, is sort of a restriction on that person's freedom of movement. So they're kind of more economically dependent on their current employer. This economic dependent on the current employer or upon an employer is a big part of the decision that came out yesterday. And it's sort of it's a phrase and a philosophy that comes out most often in Democratic administrations of the labor board, where when you're assessing the relationship between employees and employers, you need to think about the fact and understand the fact that employees are economically dependent on their employer. So there's this assumption that anything an employer does is sort of coercive to people who are economically dependent on them. That is something that we see as sort of a theme in a lot of the current board decisions that are happening. And then finally, part of the way that they reach this non-compete violation is on like non-solicitation agreements or commitments within which you would commonly see in a restrictive covenant or in an employee agreement, that if someone leaves for greener pastures, they should have a right to call their friends and say, come on, jump the fence, greener pastures, everything's better over here. That is sort of a collective protected action that has never really been seen in that light before, but that they're saying it is. And so if you try to restrict someone from soliciting former coworkers to join them at a new place, you're violating a Section 7 right. So so we'll kind of go back to the main event here with confidential information and trade secrets, but just you know, the purpose of my section here is really to just know that, you know, the labor board is looking to get involved in your workplaces at a degree that they never have before. That's a direction from the leadership in Washington to the regional offices that govern, you know, the various states and respond to complaints. And that once they're sort of in the door, once there has been a charge, they will start looking at your handbooks. They will start looking at policies. If there's a separation agreement that has been reported to them, they might, they're going to be looking at that very carefully. And this is also at a time when they're seeking greater penalties from employers and different types of penalties than they have before. So in the past, labor law violations could be seen accurately as maybe not carrying a lot of teeth and not carrying a lot of weight to the penalty. And the board is doing everything it can to put dentures in the toothless law and give people something to be afraid of when a regional lawyer comes knocking.
So Jack, while we're handing back the clicker here, I'm not going to leave you alone quite yet. So I asked this to Bree, let me ask it to you. You referenced the pendulum swing, and I see all these downcast countenances out there as they listen to what the NLRB is doing, whether it's what goes around comes around or what have you. What do you see coming down the pike here? I mean, is this going to stand? I have this mental picture of the Supreme Court kind of rubbing its hands. Oh, please send us this, because we just won't have any patience for it.
You know, I am not going to be as bold as Briana was and make any predictions at all. Other than I think it's, you know, we think of this pendulum that swings back and forth. And I think it would be accurate to say that when the pendulum went, you know, to its kind of Democratic side at the end of the Obama administration, that the Trump administration's labor board put a jet engine on the pendulum and sent it back the other direction. The current general counsel has caught that, removed that engine, put on a bigger engine and fired it back the other way. So I think that, you know, and so I think there's just, it maybe the depth that the swing is going, the direction that it's going. So this decision yesterday, we're still kind of unpacking it, but that it isn't just that it adopted a previous rule, it adopted a previous rule and then it made it tougher. And so that's the sort of thing I think that under the current administration, we would continue to see, is that it's not just finding a previous sort of pro-worker rule, it's finding that and then adding to it as much as possible, and that will just continue. I don't know, I mean, so labor law is an area where even, I don't know well, it is a place where the field has absolutely been cleared by the National Labor Relations Board, and the federal courts have a certain amount of deference to the board in this area. That doesn't mean that the Supreme Court wouldn't undo any of these rules and cases if a case were to come up before it.
All right, thanks, Jack. All right, now we get to what you've all been waiting for, the Minnesota, I think anyway, the Minnesota non-compete ban. We want to save as much time as possible for kind of our practical guidance. So let me move through this pretty quickly. The ban was effective July 1, so we're a month into it. You are now all subject to it. It applies to employees and individual independent contractors. I'll come back to that. Let me emphasize that. This is not just employees. This applies to independent contractors. So if you had an independent contractor agreement with a non-compete, that is subject to this ban now. We're not quite California, and I'll come back to that, but we do have a very broad non-compete ban. The legislature, you know, touched on geography, it touched on time, it touched on industry, to make sure that the scope of the ban was as broad as possible. So the ban applies to any agreement that would restrict the employee from working for a particular period of time, 2 days, 2 years, any period of time is within the scope of that. We're going to specify geographical area. Again, it could have been within the realm of reason we're all kind of used to, but now any geographic limitation is out the door, or work for the employer in a capacity similar to the employee's work. So sort of an industry business line restriction. There's a limited carve out for change of business control or dissolution of a business consistent with current law and current expectations, but a very categorical ban on non-competes now in Minnesota. Now, that said, I said it wasn't quite California here in the North Woods because we're different in a couple of respects. The statute doesn't ban non-disclosure agreements. And that's, to be sure, true of California as well. It also purports not to ban agreements designed to protect trade secrets or confidential information. So I'm going to talk about what I see as some open questions here. And this is the first one. And I said open-ish because I don't think this is probably going to get any traction if employers want to take it. But the language permits this argument. And that is there room for an argument that my non-compete applicable to this employee is really necessary to protect our trade secrets? Again, I think that would probably be a stretch too far, but the argument is available under the language of the statute to say that a non-compete is designed to protect our trade secrets, and therefore it's within this particular carve-out. Particularly unlike California, the statute also doesn't ban non-solicitation agreements. I said it twice, so it must be true. So a pretty expensive carve-out for non-solicitation agreements, as well as agreements restricting the use of client or contact lists. I think I'm starting to get a sense that there's some uncertainty about what a client or contact list is. I joked earlier, nobody has lists anymore. You have databases and you have servers and the like. And so what's the intersection between a carve out for an agreement that protects a customer list and what all of you have by way of customer information? So we'll see that. But what I think is particularly interesting is that there is no limit to the carve out for non-solicit agreements. So historically, non-solicit agreements have been subject to arguments about legitimate business interests. And the argument has always been available that you can't stop a salesperson in one territory from soliciting any of our customers anywhere, because what's your legitimate interest in that? They have no goodwill with somebody out of state or what have you. But the statute categorically says that non-solicits are not banned. So is there an opportunity for a broader scope of non-solicit than you might have otherwise been able to enforce in lieu of a non-compete? We'll see. Statute does not explicitly does not apply to non-competes entered into on or before July 1st, 2023. A question we're starting to get, and there's no clear answer to it, is what about a renewal of an existing non-compete agreement? It's not a new agreement. In the sense that we're just renewing something or amending something, whatever it might be. But in a sense, it is a new agreement that has a new term or what have you. So I think we're probably going to see some litigation around employer efforts to amend or renew an existing non-compete, the employee saying, wait a minute, that's a new agreement, and therefore you've got to drop that non-compete. Independent contractors, I mentioned. Now, it's not any contract party. It is individuals. And you understand what the legislature was getting at here. They were trying to make sure that employers didn't misclassify just an individual worker as an independent contractor and say, well, we're not going to hire you. We're going to engage you as an independent contractor, and therefore we can have a non-compete for you. So pretty broadly, the legislature said individuals who are paid on a 1099 basis are subject to this. As well as business entities when an employer requires an individual to form such an organization for purposes of entering into a contract for services. So the employer says, hey, just put together an LLC, we'll give you this contract. That's how we're going to do it, wink, wink, nod, nod. So you understand what they're doing, but the language, again, is pretty ambiguous. You know, it says the employer requires the individual to form that organization in order to be engaged. Lots of these one-off single person entities already exists. What about them? You know, in this particular case, the employer is not requiring it because somebody already has their own work from the basement LLC. Well, if the employer hasn't required it, but the individual comes, hey, I want to engage with you as an LLC. Is that a legitimate independent contractor for which you could have a non-compete? I think that's an open question. There's a new choice of law and forum restrictions. Again, you're going to get a theme here that there's a lot of ambiguity in the language of the statute, and this is no exception. The choice of law and choice of forum ban is very broadly stated at the outset. You cannot have a non-Minnesota choice of forum or choice of law provision in an agreement with a Minnesota employee. Period. That's how it reads at the beginning. Now, in the legislative process, the employer community went to the authors, went to the interested parties and said, well, that's really, really overbroad. And there was an understanding about that. You could have benefits agreements. You could have any sort of number of agreements that have no connection to these restrictive covenant issues. And so the answer to that, for what it's worth, is subpart E of this section that says that this subdivision only applies to claims arising under this section. So now an agreement becomes a claim, and a broad ban on non-Minnesota choice of law only applies to claims under this section. So only in the context of litigation around this. There's a lot of messiness here. I can tell you with certainty that the intent was to limit that choice of law, choice of forum restriction to non-compete issues. But we have some messiness in the language that will have to be resolved through litigation, I'm afraid, as well. So, lots of other questions. We'll invite you to follow up with us as these things occur to you. But in the time that we have remaining, let's talk about some practical things. Do we have our code up here? I think we'll probably put it in the chat, and for those of you who are local, we'll take care of you here. All right, so let's try to be practical. Let's talk about some key steps to protect the business interests that we've been talking about. Jack?
So an important thing to keep in mind is, one size does not fit all when it comes to when you're drafting your agreements. There is a very strong reason now to consider whether your template restrictive agreements are really the way you should go forward, as opposed to looking at, what are the business interests you're trying to protect? Who are the employees within your organization who should be subjected to a restrictive covenant? So it's not everybody, but it's certain job classifications, it's certain positions, it's certain departments. Maybe there's different agreements for different departments. So, a good key takeaway is just to be sure to be thoughtful about what you're bringing to bear on which groups of employees within your organization. So here's sort of just some more issues, sort of with what I was just saying. So when you're looking at non-competition provisions in those places where you can bring them, or non-solicitation provisions, the sense of what is reasonable is going to vary depending on the interest that you're seeking to protect and the person against whom you're seeking to protect to enforce it. And some of those questions are going to be, what's the geographic scope? Is this somebody who competes nationally? Is it just Minnesota? What is the amount of time that is an appropriate restriction to impose on an employee in one area versus another area when you're seeking to kind of craft these agreements that are not, a one size fits all, a template that we apply sort of across the organization.
And the same is true for non-solicits. So take a look at your non-solicits, whether it's a customer non-solicit or an employee non-solicit. If you're using these clauses to protect your legitimate business interests, take some time to really reflect on why you need them and how they can work best for you to protect your interests. So, you want to think about things in the customer non-solicit, like which customers actually need to be in the scope within this provision. We recommend to clients that they generally limit the customer restriction to customers with whom the employee actually dealt while working at the company. If it was, their customer they met, sometimes the provisions are drafted that way, otherwise came to know through their work with the company. But basically the bottom line is they met them or they worked with them while they worked for you. One point I want to make on this customer non-solicit issue is really reconsider overly broad restrictions that reach too far. And that would include things like, this agreement prohibits you from soliciting or accepting business from any customer that you worked with while you worked here. That goes a step too far because, and courts have addressed this in lots of cases that I've worked on and cases that I've read. It goes a step too far because it really gets to customer choice. Customers have the right to choose who they want to work with. And so you can reasonably restrict your employees from going out and taking all of your customers, reaching out to them, but saying, hey, customer, you can't follow this person if you want to, goes a step too far. And is likely to be interpreted as overly broad and just sort of stifling competition. So beware of those. That could lead to a court saying, no, this is not enforceable. Likewise, on the employee non-solicitation provisions, consider which employees need to be within the scope of that. Is it employees that they worked with, employees that they knew, employees who reported to them? Where do your interests lie in restricting an employee from soliciting others on their way out the door after they've left for a period of time? And be careful of prohibitions on hiring an employee. So again, you can restrict an employee from soliciting your employees, but if the provision also says you're prohibited from soliciting any employees of the company with whom you worked while employed, or hiring them to provide any services for you, that may go a step too far. Again, kind of along the same lines that Jack was discussing with the weaving logic of the NLRB, courts look at this and say, you know, if you're prohibiting the employee from hiring them, you're actually prohibiting the unrestricted employee from leaving, or you're actually prohibiting the unrestricted employee from going to work wherever they want. And that there's no restrictions on that employee from quitting. This is an at-will employment situation. They can leave if they want to, but by saying that the restricted employee is restricted from hiring them, you're interfering inappropriately with that relationship. And for that reason, it's overbroad. And that may lead to a provision being unenforceable. So keep an eye on things like that. Also, the same goes for restrictions on vendor supplier protection. So we see a lot of these just kind of what I'll call boilerplate restrictions. You know, you can't, when you leave, you can't solicit or do business of any kind with anyone that we work with, any supplier, any business, any contractor, vendor, whatever the language may be, depending on your specific business. And there may be good reasons to include restrictions like that. There are certainly cases where the relationship between the company and a vendor or a supplier or some other contractor needs to be protected. There's confidential information, there's trade secrets, there's certain preferences business preferences that exist in that relationship, and you want to restrict your former employees from interfering with that relationship, especially if it's a supplier that only has so many contracts that they offer, and interference might mean that the company then loses out on the ability to work with that supplier or vendor. So there may be legitimate reasons to restrict those sorts of interferences, but that is distinct from broad restrictions that just prohibit any sort of solicitation or doing business with. And I used an example earlier with Ryan of, if you have a vendor that supplies your office supplies, your pens and notepads, there's not really any harm probably that can come from an employee leaving and then soliciting that vendor to supply their office supplies for their new competing business. And so that sort of prohibition, if you sought to enforce it, a court might say that's too broad. It's not necessary to protect your legitimate business interests. So focus on interference versus just broadly doing business with or soliciting. And then the fifth point on this slide is obtaining acknowledgements that the restrictions are reasonable. Again, this is language we see in lots of these agreements. You kind of think of it as boilerplate. You don't really know why it's in there, but it can have a meaningful impact on whether or not a court decides to enforce this agreement. So you want the employee to not only acknowledge that they agree that the restrictions are reasonable and they're necessary to protect legitimate business interests, also that, this agreement won't prohibit or prevent the employee from earning a living. All of that is important, but try to tie it into the information that they have access to, or the relationships that they're going to be engaging in while they're providing services for your company. So even just a sentence above kind of the two sentences I just described is something like, I will have access to confidential information. I will have access to trade secrets. I will be developing goodwill on behalf of the company. And that is the basis for these reasonable restrictions that prevent me from soliciting customers or employees or whatever it may be after I leave.
All right, let's keep going. Number 6, reconsider non-disparagement provisions. This gets back to what Jack was talking about in terms of legal basis for this. As he said, there's different rules that apply to management and non-management. If you've got an executive employment agreement, you can sure have a non-disparagement provision there. If you have something for an agreement with someone who's non-management, you can't now, at least according to the NLRB. You could have a non-defamation section. We're putting that in for a number of clients. There's some prophylactic value, although it doesn't really add anything substantive to existing law, but there's some prophylactic value to it potentially. But I guess what I would say is just think about whether you need to have that in your agreements. Is that really critical for you to tell an employee where you're trying to start out on the right foot? Yeah, when you leave, you can't talk bad about us. I mean, there's broader interpersonal employee relations dynamics here. A lot of companies have it, and that's okay if you make that business decision. But I think we have an opportunity to think about, if maybe for nothing else, then you streamline your agreements a little bit. Is this something that we really want to take on right now? Now, number 7, I'll spend a little bit of time on. As your post-employment restrictions wane, what you can do to stop competition or maybe solicitation after they leave. Think about how to put yourself in the best position for when the employee leaves. And we all know that they are going to leave at some point. And that's what 7 is about. So consider a business opportunities provision. And so what that is, it's a contract provision that says that so long as you're an employee with us, you're going to tell us about any opportunity that comes to your attention within our line of business. You're only going to develop it for us, and you're not going to interfere with our ability to do so. Not restricting them from working outside of the company later for another company or on their own, but making sure they're not hiding the ball, making sure that they're not just pocketing the great opportunity that they learned about that's going to form the basis for their new competing venture potentially. Make sure that as a matter of contract, they have to disclose for you, to you, the opportunities within your scope of business. Now that overlaps with duty of loyalty issues already, but it's nice to have a specific contract term that you can point to in the right circumstance to say, you got to give this to us. Also consider an agreement that they will not prepare to compete. There's a lot of law out there that says as a general proposition, employees are entitled to prepare to compete. There are also cases that say that's all a matter of contract. So you can tell an employee, you can't prepare to compete. Don't sign the lease, don't develop your business plan on your own time. As long as you're with us, you're focusing on us. There's a few cases that might allow that. Review your remedies provisions. A lot of this is pretty standard for folks, but not everybody has all of these things. Number 1, make sure your restrictive covenants are independent obligations. That is, the employee can't argue that you breached first and therefore I don't have to comply with this. Make it real clear that these are an independent obligation. Tolling provisions, if they're not complying, you get the benefit of the restricted period after they come into compliance. Attorney's fees and litigation costs. If you have arbitration agreements, make sure you're carving out these sorts of disputes so you can go into court and get the injunction if you need. And then consider liquidated damages. To be sure, I don't like them because it limits your ability potentially to enforce by injunction a restriction if you've said, hey, there's a dollar figure that we assign to a breach. But there's also a prophylactic effect in some instances to an employee thinking, boy, if I violate this, I know I'm on the hook for X. So consider that. Make sure you have adequate blue pencil language. Make sure that you have language in your agreements that a court can not only strike out invalid provisions, but can reform provisions that might be overbroad to come into compliance to the minimum extent necessary. Make sure you know the law, but there's so many dynamics, so many changes, probably prudent to kind of sprinkle in that you're going to enforce these to the fullest extent permitted by law. Don't overuse that. It's not a total crutch, but consider having that in there because you don't know what the law is going to be next week, much less next year. Double check your consideration requirements and choice of law and forum rules. We talked about the choice of law and choice of forum, but here's a plug. Minnesota, super strict that continuing employment is not enough for consideration for a restrictive covenant. So make sure you're being very upfront that this is required for new employees as a condition of employment. That's in the first communication, that's in the first email, that's in the offer letter. And if you need to do, or if you choose to do something like this for existing employers, find a way to offer them something else. Let's see here. Forfeiture provisions. These are a little bit different in the sense that it's not a prohibition. I can't really get into this. It's not a prohibition on competing. But it's saying that if an employee chooses to compete, they're going to give something up. It might be a cash bonus, it might be stock options, it might be restricted stock units. Here you go, employee, we're giving this to you. But if you choose to leave and compete, you've got to give us back. There's common law cases that support that. Interesting dynamic that we're starting to explore, ERISA. If you put that provision in ERISA plan, ERISA might preempt a state statute like Minnesota. Now there's limits. A competitor who wants your employee that bad will just pay them the value of that they're forfeiting, but it might be an option to limit. Oh, we're out of time. We talked about reviewing your trade secret protections. I don't have time to go through that real quickly. I'll try to do this in one sentence each. Consider a SWOT analysis. Think about where your risks are. Be deliberate about it and plan. Number two, no solos and no silos. What I mean by that little catchy phrase is don't put one person in charge of your key client relationship. Have a team, have multiple touch points. So if that person or even a small team chooses to go, you're not going to lose that client just under the employee choice doctrine. Make sure you've got that, you have multiple touch points so that you can maintain that relationship if somebody chooses to go. Consider employee motivations. The one sentence, happy employees don't join unions and they don't violate the restrictive covenants. So just stay attuned to your culture, to your complaint mechanisms, to your employee engagement, because as these restrictions start to go away, it's more important to keep your folks happy and be proactive. That could be a number of things. Stay on top of this thing. If you see an employee who is unhappy, engage with him. If you see an employee who looks like they're starting to do something that might be competition, get ahead of it. And you could do that in a number of different ways. But don't just sit back and think that you'll just wait for that employee to leave. Stay ahead of it, stay on top of it.